Calificas para ser legal. ¿Quieres saber? Solo llama al abogado Andrés Mejer.
Last segment, I want to talk about case studies. Specifically, what happens if you have an order of deportation? Can you still get a green card in the United States? I am right now outside of ICE's office in Mount Laurel. I will be going very shortly with my client who has an order of deportation and is going to check in with ICE. Let's first talk about Juliana and Fernando. They came to speak to me last week. They hired a Philadelphia attorney who just recently lost his license. Now, Juliana is a U.S. citizen, although her family's from Brazil, and Fernando was born in Brazil. He entered the United States without permission or illegally. Fernando was had filed for asylum for some unknown reason, I'm not sure why, went to trial, lost, filed an appeal, lost, all with an attorney. Then he married Juliana, and Juliana filed for Fernando. They were assigned an interview for the I-130 to document the relationship. That's the immediate relative petition. And the attorney did not go with them. Well, one, because he lost his license. But they did meet with him, and he still wanted to charge him to send somebody, which was very nice of them. Didn't explain to them what was going to happen. Either because he didn't know or he just didn't care. And Fernando was immediately detained by ICE. Obviously, Juliana was in tears. Her whole family was there. It was a really sad situation, but it was 100% foreseeable. What they needed to do was to go to the interview with a stay of removal request and a valid passport already filled out and ready to go to request him to be released. If USCIS approves their relationship, which they likely would, from what I saw, they had a lot of proofs, the next step would be to file a waiver for the I-212. That waiver would overcome the order of deportation. Once that waiver is approved, it needs to file for a second waiver. I know, this is ridiculous. The standard for both waivers is the same. The difference is you can't file for the second waiver, the I-601A, when you're inadmissible to the United States for any reason other than illegal entry and overstaying. So if you have prior criminal conduct, if you have an order of deportation, you will need a separate waiver first. So in the case of Fernando, he needs to do the I-212, overcome the order of deportation. The moment he does that, he's not going to be deported. Then he needs to file for the I-601A waiver. Once that's granted, he's now overcome his inadmissibility. So today, before that waiver is approved, if he leaves, he can't come back for 10 years. That's his punishment. And he has to leave in order to get his green card. So by filing the two waivers, he then overcomes the two things that make him inadmissible. Pretty much, he overcomes the two things that would keep him from returning to the United States. And his attorney didn't explain any of this to him. Maybe that's why he lost his license. He's actually not a guy I ever heard of. I never heard of his name before. So they went to the first stage, not knowing about stage 2, 3, or 4. 100% foreseeable, 100% fixable. But they're going to have to do a whole lot of effort in a very short period of time because today Fernando is detained. So ICE is going to look to deport him as quickly as possible. That means they need to file that stay request ASAP. Once that's granted, then they need to file the I-212. And once the I-212, then the I-601A, then he gets an interview in Brazil at the U.S. Embassy, leaves there, has that interview, gets the stamp, which makes him a green card holder, and he can enter the United States. Now, how do I know it's possible? Because I've done it. Matter of fact, I'm here outside at ICE's office on almost the same case to do that very thing. Except in this case, we already have the I-130 approved. My client, so his name's Arav, it's not his real name, and his wife's Kira, who's again a U.S. citizen. Arav is from India. He has an order of removal. He is married to a U.S. citizen. At his first interview, USCIS approved their relationship, the I-130. ICE did put an ankle monitor on him rather than detain him. 3 months later, we got it removed. Now, he does need to check in regularly, which is what we are doing today. Arav and Kira are working on their I-212 waiver. The moment they have a solid case. We got Arav employment authorization. He got his commercial driver's license. He was a truck driver in his country, and now he's doing it here in the United States. So he will be going for his waiver, and then his second waiver, and then he'll be traveling. But he knew what the process were because we explained to him. There was no real surprises here because we told him what to expect. This is doable. It just takes preparation and a lot of time and energy. So if you have an order of removal, it doesn't mean the end of the world to you. You still might have some options like a U visa or a family-based petition, parole in place, VAWA. If you're a minor, special immigrant juvenile, there's always asylum. If you're afraid to go back to your country because of something that happened in the past year. So, my name is Andres Mecher. If you have any questions or issues, please comment below. If there's particular case studies you'd like to hear about, whether it's parole in place, special immigrant juvenile, we've seen just about everything, and we've done just about everything. So, if there's a particular story you'd like to hear, let us know, and we'll make a segment about it. Thank you very much. Until next time.